Welcome to our the inaugural event, of which will be a monthly webinar related to intellectual property issues and business structuring within the legal environment. As things are starting to change, in particular things with artificial intelligence and rights of publicity. There are numerous things that are happening at a rapid speed because of technology. And so what we're going to do is provide essentially a monthly insight into what's going on. And so after this particular webinar, you're also going to receive a survey, which will, one, ask you kind of, how do you think the webinar went, but it also will address what particular issues you'd like us to drill down on. And for most of the webinar events, we'll have a special guest. Today's special guest is Albert, and he works for the actual the patent office, and so he'll be giving us some of the insights that he's saying, from the inside. Each speaker will have approximately 15 minutes. They'll give kind of a 10 to 15 minute presentation on content that they feel is relevant, and then we can have a 5-minute Q&A. The way that the Q&A will work is that you'll add, you can click on your chat box, and then actually enter information in that chat box, any particular question that you'll have. And then at the end of the 3 presentations, we're going to have a wrap-up of about 10 minutes in which all questions will be answered. So I see other people have started to enter, so let's get going. I'd like to introduce Emmanuel Coffey. He is the managing partner of CoffyLaw and the host of the event. Emmanuel?
Okay, thanks. My name is Emmanuel Coffey, and again, as Ron indicated, I'm the managing partner of CoffyLaw, and we welcome you to this webinar tonight, and we hope you do learn a lot from it. By way of background, I started out as being an electrical engineer. Then I went to law school and became a patent attorney. I worked at the patents office for a couple of years, and I went into private practice. Right now, I specialize in immigration law and patent law. So those are the 2 areas that my main focus are. As for tonight, the goal is really, this is a primer. Again, we're not going into any details. Again, each of us will have 10 minutes. I'll start, and then Mr. Boyer will have his time, and then with Mr. DKD, we will spend the final 15 minutes through Q&A. All right, we start now. We'd like to start by looking into why IP now. The IP has been said to be the commodity and currency of the information age. Today, intellectual assets transactions account for more than 20% of world trade, or approximately $70 billion. And I believe those are 2016 figures, and I'm sure they have changed by now. Again, there is a lot happening in the IP space, technology as a whole. We have Industry 4.0, Internet of Things, the Internet of medical things, blockchain, artificial intelligence, 3D printing, And the big thing lurking in the background is really quantum computing, because once we have quantum computing comes into the space, then it's a game changer. Everything else will change. So we're waiting and looking for AI. And today in the United States, IP accounts for about $6.6 trillion, or 38.2% of GDP, which is 52% of all U.S. merchandise exports. So that tells you really the significance and importance of intellectual property. Again, the rapid growth of IP coincides with the emergence of digital economy. Back in 1975, the five largest U.S. companies were IBM, ExxonMobil, GE, 3M, but today in 2018 they are Apple, Alphabet, which is owned by Google, Microsoft, Amazon, and Facebook. That tells you how the world has changed. It has changed a lot, and it is changing very rapidly. There was a saying that technology changes at about, I think, every 18 months, and there is something is changed, or let's see, the time to leave TTL of IP is about 18 months. So that is how rapid the changes are made. Before you know it, whatever you know, you have to start over. So that's the background upon which we operate today in the intellectual property space. It's very complex and complicated, and again, tonight we're not going to go into all the details. We'll just, again, this is just a primer. Okay, next slide. Again, in the mid-1970s, tangible assets, machinery, and all sorts of tangible assets of corporations made up about 80% of a corporation's value. And the remaining 20% was in intangible assets, such as intellectual property, like patents, trademark. We'll go into all the other details. Today's, it's just the flip. It's the flip side of it. 84% of a company asset is made up of intangibles versus 16% of tangible assets in terms of machinery and all these other assets that a corporation use. Today it's mostly intangible, 84%. Okay, we're going to spend some time here on this slide. But again, for those of us who are not patent attorneys or who are not very familiar with IP, we would like to take the time to go over some, not all. This is not an inclusive list, but at least the major IPs are listed. First one being patent. The patent is the form of protection. That's how the intellectual property is protected. The intellectual property that is protected is like subject matter. In terms of subject matter, you have, like, for example, it can be mechanical, it can be electrical, it can be computers, it can be bio, it can be anything, any inventive idea, except for laws of nature that an inventor comes up with, is protected by patent. One type of patent, which is a utility patent. Then there is another type of patent, which is which protects the looks, the appearance, the aesthetic value, which is a design patent. So you have those are the subject matter that is protected by patent. Then we look into copyrights, which is again another form of protection, and the substance being protected is any works of authorship fixed in a tangible medium. For example, an art, a piece of a book, a poem, all these works that are fixed in tangible medium are protected under copyright. We'll go into more details about copyright. But again, at the time that the work is fixed in a tangible medium, it has protection, meaning anything that is written on a piece of paper is protected under copyright. And we'll go into why we should register the copyright. But conventionally, the copyright protects any work that is fixed on a tangible medium. The artist paints has a painting, it's protected right away. Now, does it pay to register? We can go into that later. In terms of trademarks, again, trademarks protects sound, device, symbol, word, phrase, brand name, or any combination of these you can are protected under trademark. It identifies the source of the service or product, source and quality associated with the service or the product. We all know McDonald's. We all know about Burger King. We all know about Mercedes, and those are all trademarks. Okay, moving right along for trade secrets. Trade secrets protects a process, know-how. It could also protect recipe. We all know about Coca-Cola. Certain other IPs are like databases. There are millions of private databases out there. Customer list, that's protectable. Video, audio, visual materials, all that is protectable. And there is this this category B2B or business-to-business rights, such as use rights, broadcast rights, etc. Those are intellectual property. Now, what are they protected? Can they be protected under patent, copyright, trademark? We're not saying so, because a contract is a contract. For example, use rights, which could be a contract. Broadcast rights could be a contract. Now, what is broadcasted, which would be in the form of video, audio, visual material, that can be protected under one of those patent, copyright, trademark, or trade secret. But the right itself, if it is in the form of a contract, then that's the protection right there. It's a contract. It's not. It would not be protected under patents, copyright, trademarks, or trade secret. We're saying franchise agreements, for example, is also a B2B right. Other B2B rights could be like mortgage servicing rights, sponsorship agreements, marketing rights. All these are intellectual properties now. So we would have to determine under what form of protection those IPs can be protected. And the reason why we are going into this is because a corporation, in order to obtain or to file for insurance, they sometimes do not really, their inventory is not as complete as it should be, because a lot of these rights are left out, or they're not evaluated, but they all have some value. Okay, moving right along, we have public rights.
A time check. Man, you have 5 minutes left.
5 minutes left. Okay, thank you. Public rights, again, one public right, which is a very important right, with the wireless spectrum rights that cell phones and all these other wireless devices operate under nowadays. So that's all right. Brand equity. You have a brand. There is the goodwill associated with the brand, and it has some value. I think Radio Shack, for example, even after they went out of business, was sold for like $25 million or some number like that. So brand equity has some value. And then we have rights of publicity, and especially nowadays, you have the social media influencers, mini and micro influencers. I think it's about 1,000 someone decides that they're going to standardize it, and they decide to use 1,000 or some number. Where do they get it from? I do not know. I don't have much more time left. I'm going to have to run through here. Okay, we said that there are 4 forms of IP protection. It could be patents, and the patent can be a utility patent, it can be a plant patent, or it can be a design patent. We went over the subject matter that is protected under a utility patent. A plant patent is just like it says, it's a plant. And then a design patent, like we said before, it protects the looks, the aesthetic value of a product. For example, your iPhone, it has those corners that are rounded. There is a design patent for the iPhone. That's why Samsung cannot use the same form as an iPhone. As we said before, copyright is again protects any author works of authorship fixed in a tangible medium. As soon as you write a letter, that letter is protected under copyright. But now you may want to register the work with the federal government, because that allows you treble damages, and it's also a form of notice, so that people are on notice that you do own a copyright when you register it with the federal government, and it allows you treble damages in case of infringement. Moving along, we'll go on the trademarks. Again, there are you have the regular trademark, and then there is a service mark for a service, and collective marks. There also is something called a family of marks. We're not going into that tonight. Again, what can be trademarked is a sound, word, device, symbol, brand name, and any combination thereof can be trademarked. As for trade dress, we all know about Coca-Cola. I'm sorry, I said trade secret. I don't know why I said trade dress. Trade dress is separated apart from trade secret, which should have been listed here. In fact, it was left out, trade dress. Anyway, trade secret, one example of trade secret is Coca-Cola. It's been held in secret for however long, whenever they came out. Trade secret used to be only protected under state law until a couple of years ago. There is the Trade Secret Act that it's now federal. So trade secret now enjoys federal protection. And that's all I have. Am I in time? Do I have?
Yes, you are a little over, but we haven't gotten any questions.
My name is Leonard Boyer. I have a dual role. I'm partner in CoffyLaw, and I'm the senior partner of Boyer CoffyLaw, in which Emmanuel is the managing partner. And what I'm going to talk about today is the business structure for how to protect everything. Because to develop your intellectual property requires a great deal of effort, but it all would be for nothing if it can't be protected. Now, there are several ways to protect your property. The strongest protection and the most complex to set up is the New Jersey Corporation. This is a separate, it's what's called commonly a C Corp. It's a separate legal entity. It gives you strong legal protection against personal liability. So you can't just pierce the corporate veil. You may have heard that term. There are other types of corporations that I'll talk about where it's very easy to pierce the corporate veil. Although it's complex to set up, experts such as myself can set this up, prepare the operating and ownership agreements, and it's also very important for raising capital. Angel investors and other types of investors will not invest money with you unless you're a corporation. Now, it's also good for owning multiple LLCs or other corporate entities. When you own an LLC, the LLC has to, which I'll talk about in more detail later, has to have 3 or more members. But each, let's say you're in a business. Let's say your LLC, your corporation is ABC Corporation. Then you have 4 or 5 different businesses. And each business would be in a separate LLC. So that puts 2 layers of corporate protection between you and any personal liability. And you never, ever want to guarantee anything personally. Now, there's also something called the sole proprietorship in New Jersey and in most states. This should never be used. It gives you no protection against any kind of personal liability. There's no tax benefits, and there's just no point in it. It's, you know, you're wide open. You're personally liable for everything. Now, to move on to the next slide. Okay. The New Jersey partnership is like a sole proprietorship, except it's worse because it requires 2 or more people to be involved. Again, no tax benefits, but an additional negative is you could be liable for the acts of your partners. You don't know what they're going to do, and you have no protection against what they do. Also, this is not a separate legal entity. So everything you've put together to get your intellectual property is very much at risk, but there's a better way to protect it. If we can go to the next slide.
Okay.
Now the limited liability corporation is a much better way of doing this. And in a limited liability corporation, you have 3 or more members, and it makes that, and you can't have less than that because otherwise the corporate veil can be pierced. You may have heard of 1 or 2 member LLCs. It's no good. Also, and I'm going to use real estate to show you a very easy way to grasp this concept. ABC Company is a real estate company, and I'm just using real estate to illustrate the concept. And you decide you're going to be a real estate investor. So your corporation owns LLCs. So if you have 123 Main Street, 456 Anytown, 972, some other town, and what have you. Each LLC has just 1 property in it. The advantage is no matter what happens to that LLC, won't affect the other LLCs or the corporation. So if something is wrong with the LLC, you can bankrupt it without affecting any of the other LLCs or the corporation. Now, when you have real estate and you just keep one property in an LLC, you can then turn around and sell the entire LLC and the parcel of real estate to a buyer or buyers. And that's it, that you no longer own the LLC, someone else does. And this time that becomes their headache. You just start another LLC. Now, you would have to talk to an accountant, but you've probably heard that if you have a corporation and an LLC, there's an issue of double taxation. I can't give you accounting advice, but realistically, you can offset some of that by having the LLC pay a management fee to the C corporation. Also, when you have a C corporation or you have just an LLC, you spend pre-tax corporate dollars to purchase anything that has a legitimate business use. So depending upon what your business is, your business with pre-tax dollars, you can buy things like vehicles, you can buy computer equipment, and anything else that you need to run your business. And there are some things that, can be a business expense. I would advise you to consult an accountant, or if it's a very complex matter, a tax attorney, in order to decide what you can and cannot do. Now, moving on to the next slide, I'm going to tell you about the worst thing there is. This is the subchapter S corporation, and this is the worst form of corporate structure. It is the accountant's best friend because there is so much record keeping and so much expense involved, and it gives you nothing in terms of corporate protection. This has caused many of my clients to have no alternative but to go bankrupt, both from a business and personal standpoint, and cost some of them their business. I would never, ever, ever put anybody in a subchapter S corporation. In fact, if somebody is adamant about that, I'd tell them see another attorney. The accountant loves this because it's a tremendous amount of record keeping and paperwork, and it has no legal protection of any significance whatsoever. And as I mentioned earlier, you can't bankrupt it without incurring personal liability. So there's no reason for this. Your best bet is to have the C corporation and use it with LLCs so that you have your main business and your primary business, and you are protected. So this way, you've put together a great deal of time and effort to build your business, to get your patents, trademarks, copyright, all this work, your customer list, all your sales efforts. You don't want anyone else to be able to get their hands on that. So you have to use the proper methods to protect your intellectual property. But once you have the intellectual property, so no one can take it from you, you have to have the right corporate structure. And it's extremely important because the corporate structure in the C Corp has an operating agreement. It has shares of stock, which you can sell. You'd have to consult with the securities attorney. There are various types of ways to raise capital. And once you have your property properly protected, why risk losing it? There's no point. And as we go into future webinars, we'll go over many of these things in more detail. And if you have any questions, I'll be happy to answer them.
Thank you very much. There were a couple of questions. One, in an LLC, do you value units the same way that you value shares in a C Corp?
Well, you could value units if you want to, but you're not really selling shares of stock in an LLC. You could, but an LLC is more a method of corporate protection where you're not going to be raising capital. What you're going to be, or if you raise capital, just for a limited purpose.
So your suggestion is if an entity is raising capital, they should switch to a C Corp?
Correct.
But we can move forward. I think those are the only questions. Yes.
Any other questions?
Nope. So I'd like to move forward to the guest speaker.
With us tonight, Mr. Albert DeCady, and he's a supervisory patent examiner, short SPE. And again, he's an electrical engineer, and I think he has 2 master's degrees in He's also an attorney. He's got over 25 years of experience in the field of patent. So we welcome and we would like to, on behalf of the entire staff, we would like to thank Mr. Decady for being with us tonight. Can you hear me?
Yes, I can hear you, Council Coffee. Good evening, everybody. My name is Albert Decady. Before I start, I have a disclaimer because I do not represent the Patent Office in any way, shape, or form today. So the views and comments expressed are solely my opinion, do not reflect the performance of my duties in my official capacity, and are not endorsed by, nor should be construed as, any viewpoint official or unofficial of the United States Patent and Trademark Office. So we can move on, knowing that every statement that I make today is my own opinion.
Okay. If I were to ask, how do recent court cases have reshaped the statutory landscape for patents?
Well, patent law is very, very dynamic, and any day a court case can change the landscape. However, the big case that came down was Alice. Alice changed the landscape of 101.
I'm sorry. Hold on 1 second, please. Emmanuel?
Yes.
It would be probably better if you not show like all of your emails. Right now you're showing your whole outlook.
How about now?
Yeah, you're good.
Okay.
Yeah, so the Alice case, which was a Supreme Court case, have changed the landscape of what statutory under 101 quite a bit. So that is the biggest a challenge in the past 6 years or so of finding what is statutory, what can be patented. So in Alice, the court signaled a two-pronged test looking at what's statutory. So it looks at whether your claim has an abstract idea, and that's in the first prong. The second prong, it asks whether that there's significantly more in your claim. And that test has been a big challenge for the CAFC, the appeal courts, and of course the U.S. Patent and Trademark Office that administers the patent system. Since about a year ago, the Patent Office did publish new policies or new guidelines on 101, but the exactly what is statutory is still a question under the courts.
If I may, for those who may not be familiar, could you tell us what 101 is all about?
101 is the threshold law part of the statute that allows what is statutory, right? So what is statutory is whether you have a machine, a method, composition of matter, and composition thereof. And the courts have always carved out that it also excludes, although the actual statute does not say that, it's case law that says something, it excludes abstract idea or things that are found in nature. So this test, so I guess in many years, the courts have been trying to find a precise test to see what is in and what is out. And till today, I think that precise test is evading everyone. Now, with any court case, when it comes out, it's the body of law that will continue to shape it and kind of give it its contours of what the limit is. So there are many decisions by the CAFC on this that's kind of guiding type of claims that is statutory and types of claims that have been found non-statutory.
And the CAFC is the Court of Appeals for the Federal Circuit?
Circuit, correct. And you see, as in early days of Alice, many cases that went to the lower courts and the district courts in the case were found to be non-statutory. And as cases started going to the CAFC has been drawing the line to dictate what is statutory and what's not statutory. But it is becoming a big challenge, and I think it's still a big challenge for the industry to know exactly how the court's going to fall in that realm.
Okay. Thank you. I don't know how much time we have left, but hopefully we can take another question. How will future technology like AI, artificial intelligence, 5G, blockchain change the law, or would you say that the current laws are adequate to handle these technologies?
We do hope, like every time that...
Manuel, you have 10 minutes.
Okay.
The laws would be able to withheld with new technology. But every new technology, including computers, have challenged whether the law is up to par. And 101, I keep 101 as the subject here. It's been really challenged to, and Counsel Coffey and I wrote a paper on signal claims, on whether a particular type of method, for example, stored in a computer readable medium or sent through a signal, is that statutory? And the court had said, no, it's not statutory. So this is a challenge that technology brings to whether the law, and I think it's something that the industry really needed. However, the law is not allowing it to be patented. So you do know there are efforts on the Hill. There's been a couple of hearings on trying to change the law, and I think all the major bars have sent proposed write-up of what the new statute would look like to incorporate new technology. So I'm sure the new technology that you've mentioned, AI, for example, will actually challenge the law even more. So imagine if you have a robot that is so smart that it can actually create its own invention. It starts creating without the its inventor. So there's an inventor that creates that AI system for the robot, but the robot is so smart that it starts creating new things. And let's say these new things that it creates are novel in themselves. Now, how would you have this patented? Currently, the law only gives patent to an individual, a person, a live person, not a robot. So, so you can see how in the future, when robots starts creating the new world, whose property is it, and how is it going to be patented? So definitely, there'll be new challenges as the technology advances, and the law has to stay current with it. Unfortunately, patent law is seldom amended, seldom looked at. It always lags, and therefore it will create uncertain period of time as these technologies move faster than the law, and how these properties going to be protected. But I do want to say that I think currently the system is protecting the scenario that I gave, where the robot is creating its own invention, has not arrived yet. But we can see the future that those are things that will happen, and the current law is not up to par.
So I understand there is a request for comments by the Patents Office on this exact subject matter. Should a robot be an inventor?
Yes, eventually, I can't comment on what the office is doing now, but yes, the idea is to see, do we have law that is adequate, or do we think the law is not adequate?
Okay. Anything else you would like to add? Because I see that the time we are way into the Q&A session. Do you have anything you wish to add before we go into the Q&A?
Well, there's so many. Working with the patent office, we see new technology all the time, and we are living in exciting time with 5G, with blockchain, IoT. There's all kind of new technology. AI is coming, and it's interesting. We'll see how it goes. I think the challenge for people who may be on this call here are going to be the inventors, or the people who are actually going to work with inventors and or creating businesses that are creating these things, is to stay current with what's going on in their field and in the intellectual property law. That's going to be very important. On the patent office side, I think it's the more savvy the customer or the applicants are, the better it is for the office to work with them.
Okay, well, we thank you. I don't know if you would mind to stay with us for the Q&A. We will have, 7 minutes for Q&A? There is someone who asked a question about trade dress.
I think three questions to address. The first question is, I think it's addressed to you, Emmanuel.
Mm-hmm.
And it comes from Graham Alig, from Alig Patent Law, and they wanted to know if you could give kind of a quick summary of trade dress protection.
Okay, trade dress can be protected just like trademark is protected. Trade dress comprises, or should say, consists of the entire packaging of a product. If you take a bottle of Coca-Cola, for example, you see that it has a specific shape. The label is red. The letters are white. All of that, the entire package is what the trade dress is. If it is for a service, it is the whole configuration. I'm sorry. As for the product, it's the configuration, but as for service, it's really the entire environment. Just like the product, it's the entire environment under which the product is delivered. That is considered trade dress, and it can be protected. It can be, and I think there was a good example of that Mexican restaurant. I forgot the name where the trade dress was infringed. But basically, that's how you protect your trade dress, just like a trademark registered at the Patents Office.
So do you mean, like, for example, within a restaurant, like their whole process of how they take orders and service those orders, that is a trade dress, and it is a patentable?
No. If we were, let's take a McDonald's, for example, the entire decor, the environment, the golden arch itself, it could be the trademark, but the shape of the building, that's why you see they're all the same. They tend to make them all the same generally, so that they can keep the appearance for the trade dress, because it's the entire environment, the whole decor, all that plays into trade dress.
Okay.
Yeah, and if I may add there, to receive protection, there must be two things that must be true of a trade dress, right? The trade dress must be inherently distinctive unless it has acquired secondary meaning, and the junior use must cause the likelihood of consumer confusion. So what you're looking is how the actual thing looks, and whether it is copied, and it has to be very distinctive, not any dress. But I mean, if you see a McDonald's, you're not gonna think it's a Burger King, right?
Right. Okay.
And vice versa.
Right.
For those of us who are not lawyers, what do you mean by statutory? You use that term several times.
The statutory is whether it falls in the statute, right? So the statutes are the law that governs in patent is 35 USCs. So the specific one I used was 35 USC 101. So whether it falls within that statute, with what falls within the law. And I think there's another question. Under the current law, would the inventor own what the robot creates? That's the question. Currently, patents have to be filed by a live person, not a robot. The inventor must be a person. So if you have a robot that is so sophisticated that can think as a human, who can start creating things, then the question is whether the law, as it is now, we would just start saying, oh, okay, yeah, I think a person will ask the question and says, is the invention now owned by the person who created the robot? I would be speculating to say what the law is going to say. I don't know. I don't know. The law, right now, we can't give a patent that is created by a robot.
To a robot, it has to be to an individual.
To an individual, and that individual, if an individual were to file it, but it was created by a robot, that individual is not the inventor. The robot is the inventor, but the robot is not an actual person.
Right.
Right. So that's so those are the questions that I think the law would have to resolve in the near future.
Well, it may be a long time before we see robots that are anywhere as near capable of that.
It's closer than you think.
It is. It's very much. I work.
This can be a subject of another webinar.
Yeah, I'm working with a group. We have some questions, but anyway, thank you very much. I would like to thank everybody for their time. CoffyLaw. On behalf of CoffyLaw, we would like to thank the participants as well as the audience for participating in this. We're going to be doing this once a month. You'll receive invitations to those additional events, as well as after this event, you're going to receive a few surveys as to, one, how do you think the event went, and then two, what would you like to see future events address? So on behalf of CoffyLaw, we'd like to thank you for your time and wish you a good night.
Okay. Good night.
Good night.